think.
Mr. Chairman.
Yeah.
We feel like you've been in Georgia because we've been watching. I keep trying to tease Rob Bishop and say, the reason there were so many protesters in the media, they thought Bishop was
Yeah.
sorely disappointed with his role.
Rules Committee come to order, and thank you very much for joining us this afternoon. The Rules Committee is prepared for business today. Louise, how was your weekend and your week?
We worked really hard.
Get snow?
No, it's warm up there. It's about 70. We don't know what to do with it.
Well, I'd take it.
Yeah.
Today, the Rules Committee will consider House Joint Resolution 83 as well as H.R. 998, the searching for and cutting regulations that are unnecessary, burdensome act, or the Scrub Act of 2017. Under the Occupational Safety and Health Act, employers are required to record and maintain a log of workplace injuries and illnesses that occur during a 5-year span. While OSHA inspectors have long used this information to enhance safety and health protections in America's job site, the law explicitly says that employers can only be cited for record-keeping violations within a 6-month period. Unfortunately, during the waning days of the Obama administration, OSHA rewrote the law that the regulatory fiat extended the threat of penalty from 6 months to the maximum of the 5 years. 2 federal appeals courts have rejected the very policies reflected in this rule. Further evidence is, and I believe is simply, it's just a last-minute overreach by an administration that was headed out the door. I look forward to considering H.J.Res 83, overturning this unrealistic and burdensome rule on our nation's small business. The Rules Committee will also consider H.R. 998, the Scrub Act of 2017. I believe too much regulation, especially too much outdated regulations, means higher prices, lower wages, and fewer jobs for hardworking Americans, as well as less economic growth for our country, the United States of America. This bill would provide much-needed relief to Americans and small businesses suffering from outdated and burdensome regulations. It establishes a bipartisan blue ribbon commission to identify existing regulations that should be repealed and empowers Congress to enact the commission's recommendations via a joint resolution. In other words, bringing together people from across the country who can address issues where regulations have either been outlived or exceed their opportunity to make life better for people. I'd like to welcome the gentleman from Utah, Chairman Chaffetz, to our first panel, as well as the gentleman from Pennsylvania, Congressman Cartwright. Matt, we thank you for being here, and thank you not only for being here today, but coming back with smiling faces after a week off. A week back home can always be a lot of fun. And as the old saying goes, coming to a theater near you too, I will have a town hall meeting that will be on or about March 18th, I believe, in Dallas, Texas. And so I look forward to seeing a number of people who plan to be there also. With that said, I will yield the time necessary for the gentlewoman from New York, the ranked member of the committee, Mrs. Slaughter.
Well, that's all right. I'll just wait for the question.
Thank you very much. Thank you very much. Okay, listen, what we're going to do now is try and get through this. I think I explained it, but I'm sure you can do a better job. Without objection, anything you brought in writing will be into the record, and without objection, gentleman is now recognized.
Thank you, Chairman. I appreciate this opportunity to present and talk about the request for a structured rule for the consideration of H.R. 998, the Searching for and Cutting Regulations that are Unnecessary Burdensome Act. It's better known as the Scrub Act. It's the primary sponsor is Congressman Jason Smith of Missouri. I also want to note and thank Chairman Sessions for co-sponsoring this bill as well. Every year, the federal government adopts thousands of new regulations, and the resulting regulatory accumulation is a significant problem for the federal government. The Code of Federal Regulations, the CFR, now exceeds 178,000 pages, and it contains more than 1 million regulatory restrictions. The federal government adds, on average, nearly 12,000 regulations annually. According to the Competitive Enterprise Institute, regulation compliance results in an added cost to the economy of more than $1.8 trillion. There's definitely a need for regulation. We're under no illusion that there should be no regulation. But you can see where it's particularly burdensome on a small or medium-sized business who's trying to grow in their business, and yet I don't know how anybody can go through the 178,000 pages worth of material to try to be in compliance. As you know, Chairman, these businesses make up the backbone of the United States economy, and they often cannot afford the extensive legal team to be on staff. The regulations also create significant barriers to entry for these industries. Many regulations affecting Americans today were written decades ago when the economy and the world around us was very, very different. One of the things that I particularly like about what Congressman Smith has put together here is to try to develop a bipartisan panel to look at regulations that are 15 years old and older. Let's go back and look at those regulations and prioritize that in a bipartisan way and see if we can't come up with something that will ultimately pass Congress as well. The Scrub Act establishes a bipartisan, impartial, it's called a retrospective regulatory review commission to conduct a comprehensive review. The commission consists of regulatory experts chosen on a bipartisan basis, tasked with identifying regulations that ought to be repealed or amended. In order to ensure that the bipartisan composition of the commission, the Speaker of the House, the majority leaders in the House and the Senate, and the majority leader in the Senate would each submit lists of candidates. I should say the minority leaders and the Speaker, the minority leaders of the House and the Senate, and the majority leader in the Senate would each submit candidates to the President. The President then chooses 2 candidates from each list, as well as a chair, yielding a 9-person bipartisan panel subject to Senate confirmation. So there's lots of hurdles for these people to get through. The commission then reviews the Code of Federal Regulations and identifies out-of-date, especially expensive, or needless paperwork generating regulations using common sense criteria, and I have a quick list of those. Whether the regulation has been rendered unnecessary or obsolete, considering advancements in technology and other relevant factors. Whether costs of the regulations are justified by the benefits to society. Whether regulations overlap, duplicate, or conflict with government regulation, and whether the regulation is excessively burdensome or compared to alternatives. Again, looking at things that are 15 years old and older. The commission submits the annual reports to Congress listing all the rules it identifies, as well as alternatives with lower regulatory costs and recommendations on how to move forward. At the end of 5 years, the commission submits a final report to Congress with a complete list of all the rules recommended for repeal and an explanation of the cost for each rule and a rationale for the repeal. Congress then simply passes a joint resolution to repeal the regulations identified by the commission, and the Congress can certainly reject that, but it does provide an expedited way to take them as a package and then vote on them as a whole. By recommending repeal of clearly ineffective regulation, the commission will save a tremendous amount of money, both in government agencies and the public at large. The commission's explicit goal is to reduce federal regulatory costs by at least 15%. Regulations can be necessary for health and safety, but excessive or outdated regulations only serve to divert our limited resources to efforts that waste time and money. The Scrub Act is, I believe, a sensible and innovative approach to solving the problems of a regulatory accumulation. The Scrub Act received support in previous Congresses and was passed the House of Representatives in the last Congress. On Valentine's Day of this year, the Committee on Oversight and Government Reform approved the bill without amendment by a vote of 22 to 17. Again, I want to thank Congressman Jason Smith for his leadership on this issue, and I appreciate the opportunity to speak in favor of this bill, H.R. 998, today, and welcome, Mr. Chairman, any questions that you might have.
Mr. Chairman, thank you very much. I appreciate the opportunity for the clear message that you brought to us today. Mr. Cartwright, welcome to the Rules Committee. Gentleman's recognized.
Thank you, Chairman Sessions and Ranking Member Slaughter. I do appreciate the opportunity to appear today to testify on H.R. 998, or the Scrub Act. This bill would establish an unelected commission to step into the shoes of agency subject matter experts in order to duplicate the work agencies are already supposed to be doing to review regulations, all at a cost to taxpayers of $30 million. In addition, the bill would prioritize costs over benefits through really the indiscriminate repeal of protections without consideration of their benefits. The bill would prohibit agencies from making a new rule or protection, even emergency protections that would protect the public from an imminent threat, unless the agency offsets the cost of the new rule by repealing an existing one. The bill would also entrust this newly created commission with extraordinary subpoena powers that could be subject to abuse. Importantly, there are already 2 executive orders in place that eliminate unnecessary regulations. Executive Order 13563 already requires every agency to implement plans for reviewing its existing protections. It requires every agency to, quote, periodically review its existing significant regulations to determine whether any such regulations should be modified, streamlined, expanded, or repealed, unquote. And secondly, Executive Order 13610 already requires agencies to report twice a year to the Office of Information and Regulatory Affairs on the status of their retrospective review efforts. In November 2014, a report prepared for the Administrative Conference of the United States highlighted the impact of these mandated reviews, concluding that as a result of these executive orders, the 2 of them, quote, agencies identified tens of billions of dollars of cost savings and tens of millions of hours of reduced paperwork and reporting requirements through modifications of existing regulations, unquote. Congress also has the authority and the responsibility to conduct oversight, to review existing agency rules, and to recommend or mandate reforms. But this bill seems to claim to reduce bureaucracy by creating this new $30 million commission of unelected bureaucrats to do what agencies and Congress are already supposed to be doing and are doing. And perhaps the most startling provision in the bill is that when an agency makes a new protection, it must repeal another protection based solely on cost. This cut-go provision focused exclusively on dollars and cents with no exceptions for imminent threats is dangerous, and it doesn't take a crystal ball to see how many American lives could be placed at risk. 3 prominent law professors with the Center for Progressive Reform sent a letter opposing this bill. That letter said that the Scrub Act would, quote, create a convoluted, complex, and potentially very expensive new bureaucracy to review existing agency rules and make recommendations for the repeal or weakening of those rules with little meaningful oversight, transparency, or public accountability to ensure that these recommendations do not subvert the public interest, unquote. The Commission's report to Congress containing all of these rules that it would recommend for repeal would be subject to an up or down vote by Congress. This requirement, which would not allow Congress to vote on each regulation subject to repeal individually, would usurp the authority of Congress. I urge the committee to adopt an open rule for H.R. 988. If the committee instead chooses to adopt a structured rule, I would ask that the committee make as many amendments in order as possible to allow members adequately to debate both the intended and the unintended consequences of the bill. I think the bottom line is that the bill would tie agencies' hands with unnecessary red tape and waste valuable agency resources, taxpayer dollars, and place the health and safety of Americans unnecessarily at risk. And I thank the chairman.
Ms. Cartwright, thank you very much. Mr. Chairman, there was a discussion that the gentleman just had with us about one Executive Order 13610, and he advised me, I've not looked at this, that there's a report on the status of efforts that comes out of 13563. Do you know the report he's in reference to?
I do not.
Do not. Mr. Cartwright, are you aware of that report?
Not off the top of my head, but what we can do is get that.
Okay, well, we're going to presumptively be on the floor debating this tomorrow, and I am interested, in fairness, because the gentleman brought it up, of making sure that I do find out this, as I quoted you, report on status of efforts. So I'm going to ask that your staff or your staffs between you, see if you can get a copy of that. I am interested in finding out what evidently has come out on a regular basis of their activities, I think that would be an exceptional way to enhance the debate that
I
we've got.
appreciate the chairman's interest, and we will follow up with you
Yes, sir.
on that.
Well, we're going to have to do that real fast. My guy right there is Kevin S. Hubbard, and he's Johnny on the spot already on this. So Mr. Hubbard's going to start that. Thank you very much.
Thank you.
Chairman Cole.
Just quickly, first of all, I want to thank both gentlemen for being here. Of course, a big fan of the chairman and had the opportunity to work on legislation together with my good friend from Pennsylvania as well. So I know you both be very serious legislators. When we saw Mr. Smith's bill before, I was very supportive of it then. I remain very supportive of it now. I mean, the most complaints that I get in my district are about regulations, just the sheer volume, the speed with which they come out, the duplication. I think this is a much-needed weeding of the regulatory garden, if you will. So, and I'm particularly impressed, Mr. Chairman, when you lay out the fact that there's going to be a substantial minority presence on this board, that it's going to have to be confirmed by the United States Senate. We know from recent experience that's not an easy thing to do. And that, to me, offers a great deal in the way of comfort and safeguard. Let me ask you this. When the recommendations are made, do they always come en bloc to us, or do we have the ability, and Mr. Cartwright, you can address this as well, to pull out if we decided, okay, we really think as good as this body is and as hard as they work, maybe they've made a mistake here. What would be the process whereby we could correct it if we saw something like that?
If I may, they do need to be taken in block, but Congress always reserves the right to adjust or introduce a bill that maybe included or didn't include. We may look at that and say, hey, they made 155 recommendations, but I'm making up numbers and hypothetical, 122 of them were bipartisan. Let's just tackle that, and I'm sure that we would introduce a bill and pass and tackle those. So we always reserve the right to be able to go back and do that. But this does provide an expedited way to look at them in block. And that's where I hope that the commission, in a good bipartisan way, will come together. And it'll be so obvious that their good work will come together, and there will be a significant workload of things that are done. And remember, Congress still has a say. I heard that maybe we've taken away Congress's purview, or Congress's right. It still has to come to Congress. It still has to pass the House. It still has to pass the Senate, and it still needs to be signed by the President in order to get rid of this underbrush, so to speak, and clear it out so that we have Oklahoma, Utah, Texas. We all understand how you get a good, healthy tree, and you got to sometimes clear the underbrush every once in a while, make sure that things are working well. Think of it like that. And
You know, in Oklahoma, we don't have much underbrush to clear. You know, we're pretty excited just to see a tree, let alone 2 or 3 of them together. Let me ask you this, because I'm just curious about this. And again, Mr. Cartwright, if you want to address that point before I ask my next one, please do.
I do. Thank you, Mr. Vice Chairman. What you worry about is throwing out the baby with the bathwater. I mean, there are going to be some protections. Suppose you have a up or down vote on 200 regulations, and one of them is really important. Wouldn't it make better sense, and I'm not saying one at a time, I understand the frustration going through them one at a time, but wouldn't it make sense to maybe limit it to 10 at a time, or some happy medium like that? That's why I've urged for an open rule on this, so that we can bring modifying ideas to this bill.
I'm just curious, Mr. Chairman, this is maybe even addressed to you, but I mean, is this something the Rules Committee could do if it chose to do, if it wanted to pull something out itself? I mean, we do have an extraordinary range of power in this committee in that regard.
Well, I think the jurisdiction, if the gentleman is engaging me, I think the jurisdiction would come straight to government reform. Probably it could come that there might be some laws of the country that judiciary might want to tackle, but that I think by and large it would come, and once it was given to us as a report, it would go to them at the authorizing committee.
And
But once again, I don't even know that you've even seen this report.
Well, again, and part of what this legislation does is it allows them to review the 178,000 pages, only look at things 15 years old and older, they're going to have incentives to have their good work ultimately become law too. And the more bipartisan that it is, the more likely that that's going to happen. So I think all the incentives are in the right place. But again, there's no reason why we can't look at the good work that they come up with. And I don't know if it's thousands of regulations or hundreds of regulations. And the case may be made, hey, we can mutually agree on 90% of them. Again, I'm making up a number. Maybe it's only 50%, maybe it's 20%. But somebody will then inevitably introduce that bill, and then we can vote to pass that forward.
Yeah, I agree with my friend's analysis that I think there are sufficient safeguards here, and the problem is just so overwhelming, as you point out,
Yeah.
170,000 pages. I think pretty much makes the statement as to why you want to be able to move a lot of these after a commission has taken the time, and again, a bipartisan commission approved by both bodies. And so, again, I want to commend through you, my good friend, Mr. Smith, for his work, and thank you guys again both for being here. Yield back, Mr. Chairman.
Thank you very much, gentlemen. Yields back his time. I don't know that it fit in here, but the chairman does recognize probably the set of oldest regulations that I've ever heard of is in milk production and distribution in the United States of America that goes back to the mid-30s. And that is permanent law because we've not had a chance to get 60 votes to change the permanent law, and that's why we redo the ag bill as we do it. So it might be, this is, boy, a great idea. So, by the way, I have just received from the gentleman, and I'm going to enter it into the record and then make available to any person that would choose 3 copies of immediate information that was available. I'll make sure our witnesses get this. One from the New York Times: Obama issues executive order to cut red tape. Executive order identifying and reducing regulatory burdens. Don't see a date on that. And the White House, January 18, 2011. So that's the most immediate information. Mr. Cartwright, if you can do better than that, I could use your help. Appreciate it. Thank you very much.
Okay, yes, thank you.
Gentleman's recognized.
Good afternoon, gentlemen. I'm happy to see you here. Let me clear a little more underbrush out from under that tree because the bill is written. The bill requires the commission's recommendations to be considered as a package, period,
Yes,
right?
yes.
So if you're going to talk about pulling a piece out here and there, you can't do it as the way this bill is written. You vote up or down on the package,
Yes.
regardless if something is in there which is vitally important. And you know, you talk about looking back at old things. You remember our House rules when we first did them, when they went back to the Holman Act that would allow us to dismiss or reduce anybody's federal worker's salary to $1 as part of the rules package. You remember that? It was from about 1870 something. It had never been used. Guys, you guys are so damned inconsistent, if you'll excuse me for saying so. Exactly. When I heard that they were going to spend $30 million on this, at first I was stunned. I mean, we don't even want to do a special committee to investigate what the Russians did in our election. But then I remembered, all of a sudden, because I was up doing the rule all the time on the health care bill. And we voted, some 59 times to kill that, and millions of dollars of legislative time. And then we learned last week from the former speaker, there wasn't a thing in the world here to replace that with. That we were just wasting time and wasting a lot of money. And, you know, not only that, it was not just the health care bill, 9 hearings on Benghazi, all coming up with the same answer, that you couldn't pin it on Hillary Clinton. So I realize now that saving money is a good idea that you might talk about, and even say that this would save you some money. But you're going to spend $30 million to save it. You're going to give us a package that, and that was, Mr. Cartwright pointed out, agencies do that already, that there's nothing really to see here, nothing new. And it just astonishes me, but I know that for about 2 months now, we've not done anything but shave away democracy or waste time. But when you think about the Holman Act, you remember that one? You do remember that, don't you? You explain the Holman. What year was the Holman Act passed?
Oh, I don't know.
1873?
Yeah, 1870.
Right. And that was dragged out, but I don't think any of us had ever even heard of it. And that was dragged out to be a part of the rules package now for this year. So it's just totally inconsistent to me. I know you guys have the votes to pass it, but nothing good will come from this. I yield back.
Louise, thank you. The gentleman from Georgia, Mr. Woodall.
Thank you, Mr. Chairman.
Like the haircut, Rob.
Thank you very much.
I'm trying to look more like you.
I was trying to bring some youthful vigor. Did I pull it off?
You did.
Yeah, thank you.
did.
I appreciate both of you being here, and if you hadn't heard it already, let me be the first to say it. We've been doing a lot of those Congressional Review Act procedures up here. It's been early in the year. We didn't want to waste any time for the American taxpayers. We've been moving a lot of things that hadn't gone through regular order. You got your committee constituted. You went ahead and got to work. Amendments offered to this bill, moved all the way through the process and in regular order, and it gives me great satisfaction as a Rules Committee member to be able to look at a work product that has gone all the way through the process, even with the healthy disagreements that this one has, and I'm grateful to you for that. Mr. Chairman, I appreciate what President Obama was doing when he ordered an executive review of regulatory burdens, and I appreciated what President Trump did last Friday in his ordering of a review. But dadgummit, the only regulations that ought to exist out there are ones that are intended to enforce the laws that we as a collective body have passed, and I don't surrender to the executive the responsibility of figuring out what's working for the American people and what's not. Mr. Cartwright's concerns notwithstanding, because I certainly agree with Matt that throwing the baby out with the bathwater is always a concern. But when we stand up to make those kinds of tough decisions, I don't want it to be the folks on that end of Pennsylvania Avenue who make those decisions. I want it to be us who make those decisions together. Call me an Article I cynic, but I trust us and our collective wisdom more than I trust any inhabitant of the White House, irrespective of the party he or she comes from. I look at the amendments that were beaten back in committee, Mr. Chairman, and I wanted to ask you about those. Amendment after amendment said it's worthwhile, perhaps, to look at regulatory burdens, but not if those regulatory burdens are in this category or that category or another category. If you could help me with the debate that you all had, and I'd ask Mr. Cartwright the same thing. I don't want to do away with workplace protections. I support workplace protections. The ranking member had an amendment on whistleblower protections. I support whistleblower protections, but if my whistleblower protections are unnecessarily burdensome, I want to fix that so that my whistleblowers can activate better. What was that debate as we talked about exempting categories of burdensome regulations versus looking at everything?
And thank you for that, because you're right. We did have a good debate, and people, I think, actually made a good case that, of course, we need regulations. And as I said at the beginning, there is a time and there is a place and there is a need for some regulations. But looking at those that are 15 years old and older, all we're suggesting is don't draw the picture for this commission yet. Let them have that palette. Let them go in and examine that. And those that are the most egregious, the most burdensome, the most costly, the most problematic will, we hope, rise to the surface and they'll be identified. So rather than putting limitations on where they're going to look, these are going to be professionals. They're nominated by both sides of the aisle. Like, you have to go through Senate confirmation. Let them do the work and figure out what ultimately at the end what they come up with, without trying to predetermine what those conclusions might be.
Mr. Cartwright, is that your assessment that those amendments trying to eliminate categories from being reviewed at all for efficacy was a result of people just being afraid that we would throw the baby out with the bathwater, as you suggested earlier?
I worry about that. I mean, you think about, gosh, we have an immigration issue in this country. There are people from all over the world that are desperate to become Americans. They are striving to come to our shores and be American citizens. And you have to think, what are the reasons for that? Well, opportunity in this country, but also safety and protections, and being able to drink the water without fear of being poisoned, being able to breathe the air without coming down with illnesses. These are things that are part of the American fabric, And I'm just trying to make the point that we don't want to lightly throw them away without being the deliberative body that we are meant to be. And this is a bill that casts aside deliberation. In fact, it delegates it to other people who are not elected by the people. That's my main concern. I also want to address the 15-year rule. It's not really a prohibition from examining anything more recent than 15 years. If you look at duties of the commission, it says the commission shall give priority to rules or sets of rules that are major rules or include major rules that have been in effect more than 15 years. So it's not restricted to 15 years or older. I don't know if I've answered your question, Mr. Woodall.
Indeed you have, and I'm grateful to you for that. I do share those concerns, though I trust us collectively to navigate those challenges.
And
Mr. Chairman?
If the gentleman would indulge, the unelected bureaucrats help create all these rules. These are not laws. These are rules. So when you complain about unelected bureaucrats, they're the ones that created the regulations in the first place. So to have a bipartisan group, Senate confirmed, is a whole lot better than some faceless bureaucrat in the bowels of some administration, both sides of the aisle. And I think that's an important part of their regulations, not laws, that they're looking at.
Well, I have great respect for the both of you and great appreciation for the both of you. The Oversight and Government Reform Committee does not often get mentioned as the easy committee on which to serve. The only things you all handle are things that are difficult and tough and that we all have a vested interest in. As those slings and arrows come both your directions, I will remember that the first bill that we considered here through regular order, coming through the Oversight Committee, and the committee did not have the arrogance of saying, we got it exactly right, so we want to close rules so nobody else can improve upon our work product. You said we did the very best we could with what we had, but we welcome a structured rule if the rest of the body has things to add, and I'm grateful to you for that kind of service. Mr. Chairman, I yield back.
Thank you.
I thank gentlemen very much. Gentleman from Massachusetts.
Well, thank you, Mr. Chairman. Mr. Cartwright, you mentioned that this place should be a deliberative body. I think one of the legacies of the Republican tenure in control here is that we've ceased becoming a deliberative body. I mean, the whole exercise we went through, repealing regulation after regulation under this CRA process, no committee deliberation and no amendments, and just, vote yes or no with very little discussion. That's not deliberation. That's mindless legislating. That's all about a press release. And I think my problem with this is that so much of the focus is almost exclusively on cost, but not on benefits. And I think that's problematic. But, in the spirit of, I came in a little bit late, and Mr. Chaffetz, I didn't know whether you called for an open rule or not. But I think that would certainly help make this a more deliberative process if we had an open rule. Did you have an opinion on that, one way or the other?
I did ask for a structured rule.
And why a structured rule? I mean, it's not like we don't have the time to let everybody offer their ideas. I mean, what's wrong with an open rule? We haven't had one yet this year. I think I lost count. I can't remember the last time we did, but why not try something new? Like, let everybody have an opportunity to offer their amendment, and if there's germane, vote up or down, debate it and vote up or down on it.
I am proud of the fact that through the committee process, we did do regular order. We did offer, we did have a vigorous debate. We did have a number of amendments. And what I'm recommending to Chairman Sessions is a structured rule.
Are you in favor of making every germane amendment in order?
No.
So not an open rule, not making every germane amendment in order, but limiting the process in a way that, again, will deny people who have good ideas and who have amendments that are totally germane to the process, shutting them out. Again, I don't think that's, I think, again, there's a pattern in this House that should concern not just Democrats, but Republicans as well. I hope it stops soon. But I thank you, and I yield back my time.
Gentleman yield.
Happy to yield, yeah.
The gentleman perhaps makes a good point, but I believe that what he might be in reference to, the young chairman, would be amendments that would not allow a full review of things by taking things out of what might be reviewed. Now, I don't know if I'm speaking for the young chairman or not, but in my review of today's potential amendments, it was removing things so you couldn't look at them. And I think that's a reverse analysis. I would say
Well, I would,
we're limiting. I think you saw it the opposite way.
well, if I could ask the gentleman to yield.
Yes, sir. Well, no,
Yeah,
I
I
just-
mean, I think for this committee, I think the real issue is whether they're germane to the underlying bill. And whether you like what the amendments do or not, I mean, that's what we have debates and we have votes on, and people get to make up their own minds. So so if we're adding a new layer of, you have to offer an amendment that is germane, and then we're going to add on other layers of requirements, I don't know.
Just my observation.
Yeah, no, again, I think, there's a pattern developing here where we're shutting down debate, shutting down legitimate discussion and deliberation, and I think it's not good for the American people, and I hope it stops soon, so I yield back.
Yes, sir. Thank you very much, sir. The gentleman from Colorado, Mr. Buck. You're recognized, Mr. Buck.
I'm a politician. I always want to ask questions. I asked my friend from Utah, isn't oversight a job of Congress?
Oh, absolutely. Absolutely.
And I'm just wondering, we've got a regulatory subcommittee in judiciary that handles review of regulations. We've got oversight committee. We've got oversight on every committee that I know of. And I'm just wondering, why doesn't Congress do this as opposed to form a blue ribbon panel?
Well, this bill does not excuse the role of Congress in any way, shape, or form to address more than 178,000 pages of regulations, more than 1 million regulations into itself. You can't have enough people working on this right now. Again, there are really good regulations, things that are needed, things that are important, things that are there for a reason. But to also have this bipartisan group to, authorized to look at this, they're simply coming back with recommendations. Congress still has to do its review and its discussions and its debate. So they're going to come up with a package, and that package will get an expedited review, and that we can look at it in block, as Ms. Slaughter pointed out. Look at it in block, and we're going to vote it up or down. We may decide that that's not appropriate. There may be an offshoot of it. That would require a separate piece of legislation to deal with those regulations. But that's not to excuse anybody's role in any of the committees whatsoever. But given the size and the scope and the burden and the complaints and the effect on the economy and the fact that this should be an ongoing process, I think this is a healthy way to do it. I think that's why it passed the last Congress, and that's why I hope it passes again.
And I guess I think one of the things we don't do enough around here is take tough votes. And I think we do that for political reasons. And I think a lot of these regulations would force us to take tough votes, and it's exactly what the American people expect of us, and something we should be doing more. And I think that we form blue ribbon committees to take the burden of the tough votes away from us. And I just think it may be necessary because of the volume. I think you make a great point about the volume. Not just the Obama administration, but the Bush administration and others have spent a lot of time, and we don't have as much time, as many resources to keep up with all the bureaucrats have been doing. But I would hope that we could take a group of these and hold hearings, get public input, and $30 million is a huge amount of money. But I'm wondering whether we should reduce members' salaries if we're going to give a function out to a blue ribbon committee. Maybe we should reduce our salaries and.
Would the gentleman yield? Under the Holman Act, which is now the laws here, you can reduce any federal worker's salary to $1.
I don't know that we can reduce ours under the Constitution, but I was throwing that out.
Well, just to give you an idea on the size and the scope, the Oversight Committee, which is actually one of the larger committees in terms of its staffing, on the Republican side, we have about 60 to 70 employees at any given time. There's 2 million federal workers. During the peak of the Obama administration, you exclude postal and you exclude the military, the net increase in the number of people working at the federal government went up at its peak at about 120,000. You could take that Broncos Stadium in Colorado and fill it up again. That's how many bureaucrats were added to the system in the Obama administration. These are regulators. These are people that went out and helped create all of these rules. And so it is very difficult. What I'm trying to say is let's improve. Let's add to the team. Let's add the input. Let's get some bipartisan group to go out there and offer their perspective as well. And when we spend nearly $4 trillion a year over 5 years, $30 million to help look at this regulation, to help small businesses and get government off their backs and find that sagebrush under the tree that's prohibiting people from moving forward, absolutely. And again, there's a lot of regulation that's good. I'm not suggesting it all go out, but we need some professionals to add to the team to look at what is one of the biggest burdens to the growth and expansion of our economy, and that takes away the liberties of the American people. So it's not to excuse us. It's not to say we don't have anything else to do, but it gives us another weapon to go out and do the analysis and come up with a recommendation so that this body, including the Rules Committee, the Congress as a whole, the House, the Senate, and the presidency, can vote yes or no as to whether or not to get rid of those.
Mr. Chairman, if I may weigh in.
Sure.
I really appreciate the point that Congressman Buck is making, that we have a number of our committees, like Judiciary, that have regulatory subcommittees that hold hearings, and hearings is the linchpin. That's the key word, because you can't make informed decisions if you don't hash out the facts and have hearings, such as Mr. Buck is mentioning. And this bill, 988, it doesn't provide for hearings on each of the long lists of regulations and protections that may be washed away. So we're doing so in the absence of deliberation, in the absence of taking testimony. I think that's a brilliant point Mr. Buck is making, and the phrase expedited review was used, and that really scares me. Expedited means without really thinking about it very hard. I yield back.
What convinces me to support this, Mr. Chairman, is that the Trump administration is not going to be able to fill its positions in a timely way. And without being able to fill its positions, the very people that have written these regulations and caused this problem in the first place will not be able to be used in a way that the people would want to undo the harm that has been done. Certainly, the bureaucrats in the executive branch, if they were aimed at doing good rather than evil, would be able to do this. But when the administration is being confirmed at a snail's pace in the United States Senate because of obstructionism, seems to me that we do need help in moving forward in this way. Any thoughts on that?
Yeah, well, I think there are a variety of reasons and needs to do that, but you're right. When you have a new administration, no matter what side of the aisle, and there's a roadblock and an effort at every step of the way to prohibit those appointments from going through, it does slow down the process, and so I would agree with you.
Thank you. No further questions.
Thank you. Appreciate it, gentlemen. Does any other member seek time?
Yes,
The
Mr.
gentleman's recognized.
Mr. Chairman, Mr. Buck had me on Congress exercising its responsibilities as opposed to the establishment of a commission until he got to meddling about taking something from our salaries. Then I part company with my colleague from Colorado. We're not paid enough, and very few people are willing to say that. I say it all the time. We're entering year 10 without a cost of living adjustment, and it's affecting the members of this body, and it ultimately will lead to an elite body where only wealthy people can serve. That'll be regrettable, but that seems to be where we are headed. Mr. Ch-Res, you do agree that Congress can do what this commission is going to be allowed to do.
Yes.
Then why are we establishing it if it is something that we can do?
Well, and I appreciate you asking that. As I was pointing out to Mr. Buck, our resources are somewhat strained too, given the size and the scope, 2 million federal employees roughly, and yet here in Congress, the Oversight Committee, we have 60 to 70 employees on our side of the aisle. The judiciary has less than that. It is a massive, massive task.
All right. How many employees do you think this commission is going to need in order to get its job done?
Well, I think the estimation is that it would be over a period of time, roughly $30 million type of effort.
But that's a $30 million effort, but it doesn't tell me what number they're going to need. For example, the commission is going to be paid. The commission is going to be paid their per diem and travel expenses. Where are they going to be housed?
Let me get back to you on that. I don't know where they will physically meet, if that's what you're talking about. I don't have a specific address or location for you right off the top of my head.
Right, and
I'd
while
have to
it's not built in with all of the modern technology, with Skyping and all of those things,
Oh, and they may-
is that a given that they'll be able to do that in some instances to save money?
Oh, I think there's a variety of ways that they can employ their ability to move forward. That
Well,
is the cost.
let me go to the language in the measure.
Uh-huh.
It says, and I'm reading from
Sorry, where are you at?
page 9, and it talks about in section 2 under E, the director, after being appointed, shall be paid at the rate of basic pay payable under executive schedule. And I guess that gets that person to the level 5. But then here's the thing that struck me. In general, looking on the staff, subject to paragraph 2, the director, with the approval of the commission, may appoint, fix the payoff, and terminate additional personnel. I think that's poorly structured because it seems that it doesn't have any limitations. It just may appoint. And your argument, I gather from what I hear from you, is that the $30 million is going to be the limit. But my experience with these kinds of things is they go beyond the amount. Tighten this up for me. This may appoint, fix the payoff, and terminate additional personnel. So if you hired somebody, you want to be able to get rid of them if they aren't doing the job, I understand. But may appoint who? May appoint how many? I don't understand.
Well, if you continue on to point 2, it cannot pay in excess of a GS 15 under the general schedule.
Okay, but it still does not, you hear me, but you're not hearing me. You still don't get to the how many. If you have 60 and they can't get the job done, if the various committees of Congress have staff that can't get the job done, then we're going to put this thing in the hands of 9 people who are going to have people working with them in order to get the job done. And for the life of me, I just don't understand why we don't do our job and why we are creating something, not because of just the cost, which is not peanuts, but at the very same time, creating something that doesn't need to be created. Let me ask a more general question that goes to maybe why this is being done. The argument is being made that regulations cost an awful lot, and there's currency, I think, that can substantiate some of that. But the problem that I have is, where is the evidence that the regulations have caused job loss? And am I correct that in President Bush's administration and President Obama's administration, they both came up with statistics indicating that regulations actually saved money? Now, am I wrong in that assertion, Mr. Cartwright?
You're actually correct, Mr. Hastings. The OMB estimates that the annual net benefit of major protections issued during the Obama administration, 2009 to 2015, was between 103 and $393 billion. That was the net benefit.
And the same held during President Bush's administration. I don't know the specific amount, but if I'm not in error. Either of you, please explain to me what would happen if this bill was signed into law, and then the agency needed to use emergency rulemaking to an imminent public health threat. What happens there?
Now, this offers no prohibition on additional rules or regulations. They are still, specifically in an expedited issue, this does not slow this down. Again, the bill gives priority to looking at rules and regulations that are 15 years old and older. So we're trying to look at 178,000 pages of regulations. Some are good, some are worthwhile, probably some save money. But there are a lot of impediments to small businesses and medium-sized businesses who don't have the legal resources or expertise that maybe a large multinational company will have.
Well, I'm troubled by this. I'll have an opportunity, since I'm managing the rule, to say more tomorrow. I'll leave it at this point, but I did want to make one other political point, since my friend from Colorado made one, and I want to address him specifically regarding same. Your words were that the present administration can't get its people in place and because of obstructionism. The Senate has addressed certain of the potential nominees that require Senate approval, but the administration has 2,000 jobs that they could fill in the morning if they were busy about their business that do not require Senate approval. I just want you to understand that some of this slowness is because of the chaos and not just at the hands of obstruction.
Gentleman just back his time. Thank you very much, Judge. Any other member that would seek time with our panel that is here? Any other member seeking time? Seeing none, I want to thank both of you for being here today, not only for the ability to gain information, but also to know more about this bill. And as always, Mr. Chairman, you bring exciting opportunities before this committee, and I want to thank you for taking time. Mr. Cartwright, thank you also very much. Without objection, I'd like to enter into the record the information that I've provided to our two witnesses, the ranking member, Mrs. Slaughter, and anyone else that asked for it, of information that I brought to the committee based upon the words that Mr. Cartwright had, and we'll enter that into the record. Thank you very much. Okay, we're going to move to the next panel. Next panel would include the gentleman from the committee, Mr. Polis. We'll let him decide if he wants to sit up at the dais or go forward. The gentlewoman, Honorable Sheila Jackson Lee, and the gentleman from Illinois, Raj. And I'm delighted that you're here today. You did well enough to get invited back. You dazzled the committee the other day, and so we're glad that you're here. We do not see our other two members, but we're going to go on without you. If I get the clerk, Ms. Booth, if you could please shut that door for us, we'd appreciate it. Thank you very much. The gentleman is recognized. By the way, please be advised earlier, we've stated that anything you brought in writing, we'd appreciate you leaving for our awesome stenographers who are here with us today, and thank you very much. Thank you.
Thank you, Mr.
If you could make sure that microphone's on, thank you.
Thank you, Chairman Sessions and Ranking Member Slaughter. It's very nice to be back, and thank you to all of you for allowing me to address you for a couple minutes here. I have 3 amendments before the committee that I hope you'll consider and make in order today. The first relates to the disclosure of foreign contacts. My first amendment would make sure that the commission created by the Scrub Act does not roll back disclosure requirements that any public official has with any agent of a foreign government. The controversy surrounding any potential contacts General Flynn has had with the Kremlin underscores the need for strong disclosure requirements in this sphere. The American people depend on these regulations to make sure their elected and appointed officials are working for them. Any foreign contact with American officials needs to be disclosed. My simple amendment would make sure that this commission created by the underlying bill, the Scrub Act, would not be able to roll back or weaken these disclosure requirements. So that is the first amendment that I'd like to propose here. The second amendment has to do with UAS regulations. Those are unmanned aerial vehicles. My second amendment would exempt any regulations that affect the safety of our national aerospace system. It's important to note that commercial drone operations are only possible because of FAA rules. Last August, the FAA's small UAS rule opened the door for small businesses to use unmanned systems easily and without cumbersome paperwork. The current inaction on the Flights Over People rule could limit UAS operations such as news reporting, disaster relief, and public safety from becoming a reality. As a result, many businesses and the country could lose out on the full societal and economic benefits of UAS. Once UAS are fully integrated into the national aerospace, the full benefits of these tools will help businesses to expand and our economy to grow. With a projected 100,000 jobs and over 82 billion, that's billion with a B, in economic impact over the next decade. But we need action from regulatory authorities to fully integrate UAS into our airspace. Without my amendment, the Scrub Act has the potential to stifle a growing industry and prevent the modernization of air traffic. I want to reiterate, UAS operators need guidance and regulations from the FAA so they can operate safely and without unnecessary paperwork. My final amendment has to do with noise restrictions. My final amendment would protect the countless citizens, including many of my own constituents, who depend on airport noise restrictions to sleep throughout the night or learn uninterrupted in school. Thousands of my constituents near O'Hare International Airport benefit from these restrictions, as do the millions of people that live near major airports across the country. Many of these restrictions are the product of careful discussions between airports and local authorities. While noise restrictions have a slight economic impact on air carriers, the economic benefit to surrounding communities more than outweighs this. The unelected commission created by the Scrub Act should not have the ability to overturn restrictions that have been carefully considered by local governments, the FAA, and airport officials. Without FAA noise restrictions, people and businesses would suffer. This would decrease property values in my district, make it harder for people to start a business, and have a negative effect on people's health. I want to thank Chairman Sessions and Ranking Member Slaughter for consideration of my amendments, and I am ready to answer any questions that you may have. Thank you so much.
Thank you very much. Does any member of the committee wish to offer a question for the gentleman?
Question, Mr. Chairman, but I support the gentleman's amendments being made in order.
I support them as well.
Thank you.
I would like to say that I think that the things that you've talked about would be very interesting if people did get into them. These are any rules that are 15 years or older. And I'm sure that we review them in Dallas, Texas. We review them in almost every place where we're from based upon traffic or based upon issues. It's my hope that what we're really trying to do is to get at common sense, consensus-based problems where rules and regulations have outlived their usefulness. And I appreciate and respect what you've talked about, because if people start getting into those sort of multi-jurisdictional issues, it does raise a lot of questions. I want to thank you for that. No additional questions. If the gentleman will please make sure anything you brought in writing for our awesome stenographers is left, we appreciate it. Thank you very much.
Thank you, sir.
Yes, sir.
Thank you.
Is there any other member that would seek to be heard on H.R. 998, the Scrub Act? Seeing none, the Rules Committee will now move to H.J.Res 83. The gentleman, Mr. Bradley Byrne, from representing the Committee on Education and the Workforce. The committee and the gentleman, Mr. Courtney, would also do same. Mr. Courtney, you're in trouble. Mr. Byrne has friends in his bar.
I caught myself.
And there's an old saying that at least is brought up often by the gentleman from Oklahoma. He said, "Don't ever start a bar fight if you don't have your buddies there." Well, Mr. Byrne has brought his buddies. So you're a brave man. But, and we're glad you're here. As you know, you have a very able team that is here with you also, and so I don't mean to diminish their resolve or the fight that they've got at all. Mr. Byrne, you're a member of this committee. We're delighted that you're here. I'm not used to seeing you on that side of the table, but I know that you serve as the subcommittee chair for 2 different committees, or is it 3?
No, sir, just chair for one. Vice chair for
Subcommittee?
Yes, sir.
Subcommittee, just 1?
Yes, sir.
Okay. Well, we're delighted that you're here, and without objection, anything either one of you brought in writing will be entered in the record. Gentleman from Alabama is recognized.
Thank you, Mr. Chairman, and Ranking Member Slaughter, and my fellow members of the Rules Committee. It's a little different being on this side of the table than on that side of the table, but I'm looking forward to it. Probably be instructive for my future service on this committee to sit here and do this, so I appreciate that. I'm going to submit my full statement for the record, and thank you for the opportunity to speak today. As the chair of the Subcommittee on Workforce Protections, I want to say something very clearly. Every worker in the United States of America deserves safe and healthy work conditions, and bad actors who put hardworking men and women in harm's way must be held accountable. I'm going to say that again, it's so important. Every worker in the United States of America deserves safe and healthy work conditions, and bad actors who put hardworking men and women in harm's way must be held accountable. Mr. Chairman, I said many times in this committee that in my prior life, I represented small to medium-sized businesses in employment and labor matters, including OSHA matters. Many of these businesses don't have an HR division. Typically, it's one person who's got that role and probably 3 or 4 other roles. Now, as you probably know, Mr. Chairman, there are thousands of pages of OSHA regulations. So the idea that one person has got 3 or 4 other things that they've got to do can stay on top of every one of those regulations is just not humanly possible. So what we Republicans have wanted for a long time, and I can tell you somebody that's worked with those small businesses would love to have, is to help from OSHA to help those small and medium-sized businesses, A, understand what all those regulations are, and help them understand how they can comply. Because if they do that, then we keep the injury or illness from happening in the first place. If we're coming back on the back end and citing them, someone's been hurt or there's been some illness in the workplace. And what we ought to be about is doing everything we can to keep that from happening. So what we propose and what we would like to see is that OSHA spend its considerable time and resources helping these small to medium-sized businesses do what they need to do to understand their regulations and to come in compliance with them. Unfortunately, in the waning days of the Obama administration, OSHA did just the opposite. It doubled down on punitive policies that simply failed to prevent injuries and illnesses from occurring in the first place. Under OSHA's regulations, employers basically have 3 record-keeping requirements. One is within 7 days of a recordable event or illness, they've got to log it down, put it in an actual incident report. Secondly, they have to go at the year end and make a summary of all those incident reports. So it's kept in 2 different ways. And then thirdly, those documents have to be kept for 5 years. Okay, that's a paperwork requirement for them. in aid of OSHA's enforcement mechanism and to give them information that they use to try to get information out to employers about stuff that helps in making people safe in the workplace. In 2006, OSHA issued a citation to a Louisiana-based construction company called Volks, and it did so more than 6 months after the alleged violation occurred. Now, why is that important? Because when Congress passed the OSHA law, Congress put a 6-month statute of limitation. In other words, OSHA cannot issue a citation beyond 6 months after the date of the violation. Okay. What OSHA did in this Volks case was it issued a citation for the alleged failure to keep adequate paperwork under its regulation, but the citation was issued more than 6 months after the date that the paperwork was supposed to have been kept. And so obviously, Volks appealed it, and it wound its way up through the OSHA review body. And the OSHA review body agreed with the citation, and it went from there to the D.C. Circuit Court of Appeals. And as you know, it takes several years for that process to play itself out. Well, the D.C. Circuit finally ruled in that case, and they ruled against OSHA. Now, there are 3 members of the D.C. Circuit that heard this case, and one of the persons that heard it was Judge Garland, who, as you know, was nominated by President Obama to be on the U.S. Supreme Court. Well-respected jurist. So all 3 of those members of the D.C. Circuit said that OSHA was wrong. Now, here was what OSHA argued. OSHA said, yes, there's a 6-month statute of limitations, but that 6-month statute never ends because there can be continuing violations if you don't file the paperwork. So every day you don't file the paperwork is another date of violation, and that just keeps pushing the 6-month statute out. Now, I think on its face you can see the illogic of that position. And if you read the court opinion, which is scathing, by the way, the court directly addressed the Chevron deference doctrine and said the Chevron deference doctrine, which says that the courts defer to the agency's interpretation of the regulation, it doesn't come into play when something's clear on its face. And this statute of limitations that Congress wrote in the statute, it's clear on its face, and no tortured understanding of that by OSHA can change that. That was their ruling. Well, what was OSHA's response to that? Not content to simply ignore the law, the agency decided to unilaterally rewrite it in the face of the D.C. Circuit Court of Opinion, the face of a clear statute by Congress. In December of 2016, OSHA finalized a rule that said employers could be cited for failing to keep proper health and safety regulations for up to 5 years. Remember, it's a 6-month statute of limitation. So they not only tried to rewrite our law, they did it in the face of a very clear decision by the D.C. Circuit Court of Appeals. This move was nothing more than another unlawful power grab by the Obama administration. Now, the chair of the Education and Workforce Committee, Colonel Klein, who you knew very well, and Representative Wahlberg, who chaired the subcommittee that I chair now before me, both sent a letter to OMB saying, don't do this for various reasons, but one of them was you're flying right in the face of the D.C. Circuit Court of Appeals opinion. And they did it anyway. The real shame of it is that OSHA's unlawful rule does absolutely nothing to improve worker health and safety. And in point of fact, because they're running against this very clear decision from the D.C. Circuit Appeals, they're setting themselves up for another long, tortuous appellate case using federal lawyers, I guess, to defend the OSHA position, and using all those resources to do that, which we now know is going to be a nullity because of the D.C. Circuit Court of Appeals opinion. But in addition to that, they're not using those resources to do what I said at the beginning, which is to help these small, medium-sized businesses simply understand the regulations and come in compliance with them. The goal of safety enforcement should be to prevent injuries and illnesses before they occur by ensuring everybody understands the law and bad actors are held accountable and violations are addressed as quickly as possible. By the way, that's the reason you have a 6-month statute of limitation, is to get OSHA to act on this as quickly as possible. Unfortunately, with this rule, OSHA once again took a backwards approach with the goal of punishing employers rather than collaborating with them to adopt proactive policies and prevent workplace hazards in the future. Congress should do everything it can to overturn this unlawful power grab by the Obama administration and reject OSHA's failed approach to workplace safety. I urge the members of this committee to support H.J.Res 83 and a closed rule for its consideration in the House. And I do want to say before I relinquish the microphone how much I enjoy being with the gentleman from Connecticut. He and I serve on the House Armed Services Committee together, and he is a true scholar and a gentleman and a great member of this Congress.
Counselor, thank you very much. Gentleman from Connecticut is recognized.
Thank you, Mr. Chairman, and thank Mr. Hastings for being here. And I got nowhere to go but downhill after those kind words. And it is true, we served together and have been on trips overseas with the Armed Services Committee. And
You know, it is true that what you're talking about is the way most of life is up here.
That's right.
That we really find each other and engaging, and we admire each other very much. And it shows very much, and I appreciate that. And you are welcome here, and you know that.
Absolutely, Mr. Chairman.
But your attitude is pervasive, and I appreciate it.
Yep. No, it's true, and it's overlooked and not
think
well
it
understood
is. Yes, sir.
sometimes. So in any case, I just want to begin with sort of responding to a comment that Mr. Woodall made earlier. I was listening closely to his remarks about the CRAs, the Congressional Review Act procedures that have been followed, and he made the point that they had to go forward pretty quickly because a lot of the committees of cognizance were not sort of in formation and the clock was ticking. That's not the case with this measure. The Education and Workforce Committee actually was formed on January 24th. I mean, we have had already a number of meetings, and the tipping clock on this regulation is not this week or next week. We've got some time to actually, in my opinion, follow regular order and to really try to drill down on this question, which is a very kind of fine legal issue about tolling of statute of limitations, which, again, those of us who went to law school know, you spend whole semesters studying civil procedure to try and sort of sort out, what is a statute of limitation, what tolls it, in other words, starts the clock running. And that really is sort of boils down to what the issue was in the Volk case, which Mr. Byrne referred to. And I go back to the speaker's comments on opening day where he talked about, the importance of regular order when he said that when we do not follow regular order, when we rush to pass bills that a lot of us don't understand, we're not doing our job. And I really think that, again, in this case, there actually is a little more complexity to the question of what the D.C. Circuit actually said, and also really whether or not this rule, which was issued in December, as Mr. Byrne correctly stated, really creates the outcome that we heard here a minute ago. So at the outset, when that court case was handed down, the Volk case, Judge Garland, actually, if you read his decision closely, what he said was, yes, the statute did not provide for a continuing obligation by the employer to record workplace injuries and illnesses, and that's a problem, and that's why I think he concurred in the decision that the court handed down. However, he did say that a revised regulation which provided for a continuing obligation could toll the statute of limitations. In other words, where a regulation imposes a continuing obligation to act, a party can continue to violate it until that obligation is satisfied, and the statute of limitations will not begin to run until it does. And then, again, we're talking pretty sort of fine, hair-splitting legal points here, but, the net effect in that case, and took place with the Volk's case, is that OSHA was not allowed to cite the employer for failing to record 102 injuries and inaccurately recording 67 cases going back over a period of 54 months. So, this is, when we're talking about workplace injuries and illnesses, what this outcome, if this rule is set aside by Congress, is going to do is really create a safe harbor for some of the bad actors, which I totally believe Mr. Byrne is sincere in his belief that, we shouldn't reward bad actors. But the fact of the matter is, what the court's decision without a cleanup regulation, which is what, in my opinion, OSHA was trying to do, is it basically rewards employers who do not record injuries or illnesses and allows the clock to start running at the time that happens, just as we saw with the Volk case in terms of the facts that actually occurred on the ground. So, again, the harm that's going to occur here if we don't handle with care an issue like this is really, I think, something that really should give people pause. and really not put this bill in order. And let's send it back to the Committee of Cognizance, which is fully up and running to really drill down and understand this issue better. Again, the problem with OSHA is that its staffing does not permit a regular inspection process. I mean, it's been estimated that it would be able to inspect a workplace on average once every 140 years due to its limited resources. It relies on a self-reporting system of employers. And when we're talking about workplace injuries and illnesses, as a former employer, I mean, and I think a lot of us, came to Congress with that background, we cared about our staff. We cared about our workforce. That is not a burden, which in my opinion is asking too much in terms of just simply recording a workplace injury and illness. And so before we blow up this rule, which, by the way, there's been no legal action brought against that rule that was filed on December 16th before the administration left town. We're 2 months now into that rule being in place. The fact of the matter is that the pressing urgency for Congress to obliterate it, because as you know, with CRA, the agency can't come back and try and do a fine-tuned fix. I mean, we are basically creating a hole in the system of regulation. I think this really should go back to the committee, and let's have some expert witnesses, some of the lawyers involved in the case. Let's drill down in terms of what the real-life impact will be, again, if we move too swiftly. And with that, again, with respect, I would ask that this resolution not be put in order and send it back to the Committee of Cognizance. And I yield.
Thank you very much, Gentleman. Yields back his time. I have been out of the marketplace for quite some time. Years ago, I had some 500 employees that worked what I would say within my responsibility area that worked for me as the reporting element. I've worked inside and I've worked outside during that period of time, and I don't recall what is actually in the report, and so I could not be a judge of that. But I think what gets us, or at least me as a workplace person interested in it, is it was done at the last minute, at the last possible time frame. And I think that we call these midnight rules, and I think that's what bothers most of us the most, that what had gone on for years was all of a sudden changed at the end. And I think that in no way would Mr. Byrne be trying, and I'm going to kind of take up for him, it's just my own personal perspective. I think what we're for is not lessening the burden. I think what we're for is doing something that's rational and regular that makes sense. And I think extending that from 6 months to 5 years is a burden when it was reportable anyway. And I will tell you, OSHA does get involved where there's a death. And they get involved. Yes, sir, I want to hear from you because I'm going to hear from you tomorrow because Judge Hastings and I are going to be on the floor debating this. And I'm trying to learn a little bit more about it. Maybe that's some of my interest.
So the rule that was issued in December did not extend 5 years in terms of the reporting. What it simply said is that there's a continuing obligation to report. So if you reported it on the 8th day or the 10th day,
right,
then the 6-month statute would start running from that point. And so it isn't 5 years. It's six months plus whatever the date is that the injury is reported. And I have my own experience with employers out there, particularly in the construction industry in Connecticut. They want to comply with the law, and we don't want a system that just is all about retribution. Right. And so but I don't think that this sort of clarification rule, which is really what I think that the Department of Labor did, as opposed to because really that was sort of what I think most people's understanding of what the rules of the road was prior to Volks, was that there was a continuing obligation to report. Again, they challenged it, and they were right. The statute was pretty clear that there was no continuing obligation language in the statute, but as Judge Garland said, a regulation could easily clean that up.
Okay. Mr. Woodall.
Thank you, Mr. Chairman. As you know, Mr. Courtney is one of the most persuasive and capable members of this institution, and I thought that Mr. Byrne was...
Now, Mr. Cole's not here to have you stay in line for Mr. Byrne, but
The gentleman's recognized to help him out.
Mr. Byrne is perfectly capable. When he's sitting up here, he seems even more capable when he's sitting down, sitting down there. I try to find opportunities to agree with Mr. Courtney because I know he cares about people, and 9 times out of 10, I find myself similarly situated in terms of how it is we care for folks. The erosion of trust in OSHA, I think, is one of those things that we grapple with. I think back to the beginning of the Obama administration, and the number of citations OSHA issued increased by over 150% in the Obama administration's first year on the job, increased another 100% just in the first 6 months of the next year, and continued to rise. Like you, I don't want to be in the punitive business. I want to be in the keeping people from getting hurt business. And I think of all the small business owners I hear from in my district who say, Rob, I'm trying. Right? Whether it's OSHA, whether it's the IRS, whether it's Fish and Wildlife, whatever it is, it's just a mountain of things coming down on me. And if the clock never tolls on these folks, if the burden of an honest mistake never ends, I am concerned we'll spend more time focusing on punitive measures than we do on workplace protections. I just wanted to ask you, Mr. Byrne, from your committee's perspective, I know you authored this resolution. When we repeal this midnight rule and say no substantially similar rule can be promulgated, what does happen next when it comes to our collective goal of workplace protections?
Well, I appreciate that question, and it's very important. First, just so you know, the subcommittee, when Chairman Wahlberg was the chairman of it, had a hearing on this last May because we had the draft of the regulations. So this was up before the old committee, not the present committee. So there has been discussion and review of it. If this is passed, then that doesn't mean that there can never be a regulation like it again. It just means it has to have congressional approval before they go forward with it. I happen to think that's a good use of our Article I powers, an appropriate use for Article I powers. It also means that we have to be consulted, and so often in these cases we're not consulted at all. We're going to continue to operate on my subcommittee looking at a host of issues relating to workplace safety and looking at the workplace of the 21st century. Once again, what our focus is going to be is how can we keep injuries or illnesses from happening in the first place? Mr. Courtney and I were on a Navy ship last summer. We were talking to the commander of the ship, how do you withstand a missile attack? And he said, well, the key here is to not let the missile hit the ship in the first place. So how do we help American workers? The key here is not to let them get injured or let them get sick in the first place. So our focus is going to be, how can we get that? And so I hope that that will send a signal to OSHA that what they really should be about is that. Go out and work with these small businesses and medium-sized businesses. I've seen them do it before. New regulation comes down, it affects a particular group of businesses. They get the word out to that community. Come in, let's talk about what it means, how we're going to go out and inspect it, what you can expect from an inspection from us. Boy, that cure, the cure for the illness is so much more expensive than doing the precaution. And the precautionary measures they could take if they put their energy and resources into that would be so much more effective. Having a continuing violation, which he and I have a legal difference here, but I really don't think under the present statute you can use continuing violation. I don't think that's what the D.C. Circuit Court of Appeals opinion says. But think about it from a practical point of view. How do I know, if I'm the small, medium-sized business guy, how do I know when it's over? It's never over. That continuing violation can continue to snag you. And this is not a continuing violation of something that's caused an injury. This is a record-keeping requirement. They're already required to have the 7-day report, incident reports, already have to have the year-end summary, have to keep all that for 5 years. And remember, small businesses got to find some place to keep that stuff for 5 years, have to have the process in place to make sure you keep it. So there's a pretty significant burden on the employer already. I'd rather see OSHA do what I think it can do, and that is help people understand the regulation and comply with it.
I thank the gentleman. Mr. Chairman, I yield back.
Thank you very much. Judge?
I'll have my opportunity tomorrow, Mr. Chairman, but I agree with Mr. Courtney's analysis. Particularly compelling is that there's no rush to get this done, and that we could allow the two thoughtful gentlemen that work on this committee and others to get it right. So I'll have an opportunity to talk about it tomorrow.
Judge, thank you very much. Mr. Collins?
Thank you, Mr. Chairman. And I, like Mr. Hastings, will have some time tomorrow, but I just want, this one, for me, OSHA especially in general, and if you get into MSHA and you get into the others, and really for either one, it amazes me at times that OSHA seems to operate off the premise that an employer wants to hurt their employees. That's the way it seems. I'm in a rural district with manufacturing others. It seems that they go off the opinion of every employer wants to make sure that someone goes home maimed every day. The question I have, and I don't think either one of you would agree with that, I think most employers, all employers, want to keep a safe environment, working environment. The problem I have, and I've got no problem with this bill, in fact, I appreciate this bill, I would love to see us get to the point to where we really examine what OSHA is really there for. And the fine aspect becomes a course correction or an attitude, just however you want to put that for a behavioral aspect, instead of the first visit in a 6 months or a year to be, here we're going to find as many fines as we can. I actually had a business, kid you not, came to it, the inspector came, didn't find anything, went back, was writing up the report, the supervisor said, you must be doing your job wrong, there had to be something, and sent the inspector back to find a violation. Of course, the inspector found and wrote up several things because they were being forced to say, you've got to go, enforce a fine. We've got to get back in this situation, sort of what you said earlier, Mr. Byrne, about this issue of saying that we've got to make sure the preventative is there, make sure that we're going. And if OSHA comes in and they see something, they say to that employee, here's a problem, here's why this is an issue, I'll give you, depending on the aspect, 24 hours to fix it or 48 hours or 2 weeks to whatever. But when I come back, it better be fixed. Here's how it needs to be fixed. If it is, we move forward. If it's not, we hammer you. And I think that's the problem that I have with OSHA and many of these others, is it's long left its teaching parameter. And if we just go in assuming that an employer willingly violated a rule, willingly violated having a kinked electrical hose that had a scrape in it, if we go in with that mindset, Mr. Chairman, this is not helpful to anyone. That's a gotcha game. And it's the reason small towns like Elberton, Georgia, where there's a granite industry which has OSHA and MSHA, they are more concerned about somebody finding a court or then upping the fine schedule because they come back later and find something that they classify within the same general violation, if you would, and triple the fine. This is just beyond, so I'm going to speak a little more on this now, but I wanted it out in this hearing because the chairman's talked about this being a hearing, and I wanted to have this as a hearing and say, look, we've got to look at OSHA. OSHA has a proper place. But if a teacher walks into a classroom at the first of the year and tells their students, to a kindergarten class and says, do you know your alphabet? And they say A, B, C, you're fine, you're never going to first grade. What are we teaching here? We're not giving any encouragement to get better. We've got to find a better way for OSHA to operate properly, but also provide the proper balance here. And with that, Mr. Chairman, I look forward to this tomorrow. Thank you, the author, for bringing it, and I yield back.
Thank you very much. The gentleman from Washington.
Well, thank you, Mr. Chairman, and I want to appreciate a good friend from Connecticut as well as Alabama. I couldn't let the opportunity go by without at least asking a couple questions here. First of all, I gotta say, we hear a lot of bills here on the Rules Committee, and let me just say that some are more interesting than others. Just reading about what we had coming up on the agenda, I was thinking, rules required by OSHA. That didn't sound like to be one of the most interesting, but you two gentlemen have made this a very important and interesting discussion, so I appreciate that very much. I do appreciate, too, some of your comments, Mr. Byrne, that you were talking about, and similar to the vein of discussion that Mr. Collins was following. I used to run a regulatory agency for the state of Washington, and my philosophy, and I always felt that we got much better results if we helped people comply, helped them understand what the rules are, so that they knew clearly what was expected of them. versus coming in and just fining them into submission, essentially. That worked very much better. In my case, food safety was better, environmental results were better. It was just, I think, a much better way to regulate the regulated community. The question came up was, how would this improve worker safety? I'm trying to see if this were left in place, if there would be a huge improvement to worker safety or not. Or would it be just an increased burden to a small business, a small, medium-sized business? I think maybe go ahead if you'd like to respond quickly to that.
Yeah, I mean, I think I said this in my opening remarks. That this really is not going to increase workplace safety. It is going to increase potential regulatory punitive burden on small to medium-sized businesses. Big businesses don't have to worry about this. They got an HR department.
Yeah, right.
HR department keeps up with all this stuff. They have people that work for them that do everything that are necessary. But it can happen to a small to medium-sized business because they've got that one person's doing 4 or 5 things. So I would think that it's much more of a better use of the resources and time of OSHA to work with those businesses to make sure, A, they understand what the regulations that apply to them require. Because some of these regulations are very dense in terms of safety standards, going for pages and pages and pages. You probably read them. And so in understanding what all that dense wording in those pages means for some of these small to medium-sized businesses, very difficult. So when OSHA actually works with them to make sure, A, they understand what the standards they're intended to meet is, and B, what's the best way to meet that? Because there's some practical do's and don'ts here. And if OSHA sits down and uses their resources to work with these employers, as it's been said previously, they don't want somebody to be hurt or injured on the job. That's not
Absolutely
something,
not.
that nobody wants that. But there are a few bad actors out there, and they try to skirt around the regulations, and nobody wants that to happen either. But if you give these small to medium-sized employers that sort of dedication of time and resources, then far, far, far more likely you're going to get compliance and people are kept from being injured, kept from suffering an illness from the workplace than we are ever going to get by just going out there and slapping fines on people.
In the end, I think that's what we want, a safer work environment. Did you have a comment, Mr. Gordon?
We're talking about reporting injuries and illnesses, period. I mean, I agree with every word that Bradley said about, that OSHA should be engaged with, and I mentioned earlier, construction industry, which, it's a dynamic sector, lots of new materials, building materials, and trying to educate everybody about, the risks of taking on some of that material is something that OSHA does a great job in Connecticut, at least, and I'm sure it does in other jurisdictions. What we're talking about here, though, was a regulation that just simply said you've got a continuing obligation to report an injury or illness, period. And to the extent that we don't have a regulation like that in place, basically a bad actor, in my opinion, is outside of the reach of any kind of enforcement action 6 months after an injury or illness, or 6 months and 7 days after an injury or illness occurs. And to me, that creates a perverse incentive in terms of, really trying to get to the goal of getting to the bottom of preventing and also addressing why people are getting sick or why people are getting hurt.
So I'm not an attorney, so I know attorneys always, you never ask a question you don't already know the answer to. I don't know the answer to this question. But I'm glad you brought up that subject of a safe harbor for bad actors. I wanted to ask about that. You've expressed your opinion that this could potentially create such a thing. So I wanted to pose that question to Mr. Byrne, what your reaction is.
Remember, we have OSHA's supposed to come in within 6 months. Now, why 6 months? If you've ever been through one of these investigations, let me tell you, if you go beyond 6 months, people's memories dim, you lose important pieces of information. If you want to get compliance, and Congress was, specific about this, that's what the court found in the decision. Get in there and get your job done. It's sort of a message to OSHA. Don't sit back and wait, and don't try to use this continuing violation theory, which is not in the statute, to try to make up for the fact that you didn't do your job in the 6-month period. If you're really there, if you're really there to protect employees, then get out there and protect employees. But don't just sort of let it go for months and months and months and months we start to lose people's memories, lose people's information. I've seen, witnesses where we couldn't find anymore because they've gone. They've left that employer, they've gone to work in another state, we can't find where they are. So the passage of time is the enemy of enforcement, is the enemy of getting compliance. So the 6-month statute is really, in my judgment, a good idea. It's a message to OSHA, get in there and get your job done.
Mr. Courtney?
The only point I would simply make is that, and this is why I think this really should go back to the committee, is that the Department of Labor has issued data to the subcommittee, to the committee staff, is that there has been a change since Volks, and that there's a 75% drop-off in terms of report of injuries and illness. Because again, there's just not, it just changed as a result of that court decision. And maybe people have good explanations for why that trend is happening, but frankly, the Rules Committee isn't the place to sort of drill down on that information. It's the Committee of Cognizance.
Well, as a small business person, I appreciate the effort to reduce the obligation of record keeping. And like I said, I do appreciate efforts to improve the overall goal of the agency, which I think is improve worker safety. But interesting line of questioning. I do think, even though perhaps if this passes, the agency can't go back in an identical way, but from what I can tell from the court decision, and maybe I'm reading too much into it, it inferred that this is a place where Congress should be. And so we can visit this subject again, and if there's some more that needs to happen to it besides just getting rid of this rule, and then that's maybe what the next topic of conversation should be. But with that, thank you very much, Mr. Chairman.
Gentleman yields back his time. Gentleman from Colorado. Gentleman does not seek time. The gentlewoman does not seek time. Thank you very much. I found this most instructive and interesting, and I want to thank both of you. If you'll please remember that we have one of the awesome stenographers that's here. If anything you brought in writing, if you'll leave that for her, I appreciate it. Is there any other member that would seek to be heard on H.J.Res 83? Seeing none, this now closes the hearing portion of H.J.Res 83, and the chairman will be in receipt of a motion from the gentleman from Georgia.
Thank you, Mr. Chairman. I move the committee grant H.R. 998, the Scrub Act, a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes in order only those amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule the rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.J.Res 83, disapproving the rules submitted by the Department of Labor relating to clarification of the employer's continuing obligation to make and maintain an accurate record of each recordable injury and illness under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and the Workforce. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. And finally, the rule provides one motion to recommit.
Thank you very much. You've now heard the motion from the gentleman from Georgia. Is there amendment or discussion to that?
Yes, Mr. Chairman.
Gentleman recognized.
Mr. Chairman, first I ask unanimous consent to have the statement of Congresswoman Sheila Jackson Lee made part of.
Without objection.
Mr. Chairman, I have an amendment to the rule. I move the committee strike the waiver of Section 311 of the Congressional Budget Act for H.J.Res 83. Mr. Chairman, H.J.Res 83 violates Section 311 of the Congressional Budget Act because it reduces revenue. A pattern seems to have developed in the committee of selectively enforcing the rules of the House in order to pave the way forward for Republican proposals and block those offered by Democrats. Now, last Congress, 99% of all waivers issued by this committee were for Republican proposals. We've just started a new Congress, Mr. Chairman, and the pattern, in my view, should not continue. I therefore urge the adoption of my amendment to strike the waiver of Section 311 of the Congressional Budget Act.
Thank you very much. Further discussion? Anybody seek to be heard? Seeing none, the vote now be on the motion amendment from the gentleman from Florida. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Those have it, noes have it.
Mr. Chairman, I ask for a
Gentleman asks for a roll call vote. The clerk will poll the committee.
Mr. Cole. Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Collins. Mr. Collins, no. Mr. Byrne. Mr. Byrne, no. Mr. Newhouse. Mr. Newhouse, no. Mr. Buck. Mr. Buck, no. Ms. Cheney. Ms. Cheney, no. Ms. Slaughter. Mr. McGovern.
Aye.
Mr. McGovern, aye. Mr. Hastings.
Aye.
Mr. Hastings, aye. Mr. Polis.
Aye.
Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 8 nays.
The amendment is not agreed to. Further amendment or discussion, gentleman from Colorado.
Mr. Chair, I have an amendment to the rule. I move the committee grant H.R. 998 an open rule, so members on both sides of the aisle have the opportunity to offer amendments to the bill on the floor.
Thank you very much. Discussion. Wanted to please advise the gentleman that in the motion, in the H.R. 998, no scrub act, there were 12 amendments made in order, 1 Republican, 11 Democrats. Further discussion, see none, vote now be on the Polis amendment. Those in favor signify by saying aye. Aye. Those opposed, no. No. Noes have it, noes have it. And accordingly, we will now move to the motion.
One more motion, Mr. Chairman.
Gentleman asks for a roll call vote.
No, I have a different motion.
Gentleman's recognized.
I have an amendment to the rule. I move the committee make an order and give the necessary waivers for amendments 12 and 18 by Representative Bonamici and myself to H.R. 998.
Discussion. See none, vote now be on the amendment from Mr. Polis. Those in favor signify by saying aye. Aye. Those opposed, no. No. Noes have it, noes have it. And accordingly, we will now move to the motion. Seeing no further amendments, those in favor signify by, of the motion from the gentleman from Georgia signify by saying aye. Aye. Those opposed, no. No. The ayes have it, the ayes have it. Accordingly, the gentleman, Mr. Collins, will be handling this as the floor manager.
And Mr. Hastings.
And Mr. Hastings will be handling this for the Democrats. Need to advise you that the next meeting is scheduled for tomorrow at 2 o'clock. We're going to meet on H.R. 1004 and H.R. 1009. I'd also, in one additional piece of information, recognize myself for the purpose of offering a motion for our subcommittee, and I'll recognize myself that there's what we're going to do is propose the motion of, there it is, thank you. I move that the majority caucus of the subcommittee on the Committee on Rules be constituted as following. The Subcommittee on Rules and Organization of the House, Mr. Collins, Chairman, Mr. Byrne, Mr. Newhouse, Ms. Cheney, and Mr. Sessions. Subcommittee on Legislation and Budget Process, Mr. Woodall, Chairman, Mr. Byrne, Mr. Burgess, Mr. Byrne, Mr. Newhouse, and Mr. Buck.
Mr. Chairman, have Democrats been left off of those subcommittees altogether?
No, I'm about to.
Gentleman now. The gentleman now from Massachusetts would be recognized for the purpose of.
Mr. Chairman, I move that the minority caucus of the subcommittees of the Committee on Rules be constituted as follows. The Subcommittee on Rules and Organization of the House, Ms. Slaughter as ranking member and myself. The Subcommittee on Legislative and Budget Process, Mr. Hastings as ranking member, and Mr. Polis.
Thank you very much. Is there objection to either motion that would be made by the gentleman from Massachusetts? Well, myself, seeing none, so ordered. Thank you very much. This now takes care of our work for the day.